So thank you for the opportunity to come back to the podium. And let me say that since I wasn't quite sure what the previous speakers would say, I didn't plan what I would say until after I heard what they said. And I'm happy to say that it's quite comfortable to go into the wake of Yaroslav, who has, I think, given a very good overview. And I can only endorse what he has said and what the earlier speakers have said. And let me make a plea. Let's not kill arbitration over trade sanctions. Arbitration is designed to promote global, international trade and investment for many, many good reasons. There's a reason why UNCITRAL, a UN organ, makes instruments and shepherds those instruments to promote trade. And trade sanctions, whether they be unilateral, bilateral, if in a coalition or if it's through the UN, should not undermine the international arbitration system, which has an important support function to international trade. And I think that is a key message that we have to keep in mind, and that means that we have to deal with the problems, but we need to deal with them in a cautious but still bold way, where we try to give priority to the overriding internationally accepted values. The New York Convention has been heralded as the most successful convention that has ever been ratified around the world. And it has a decidedly an accepted pro-arbitration position. And I think that the New York Convention represents a greater international consensus than do these various trade sanctions of whatever their particular character is. The New York Convention also represents over 50 years of a historical document which has been implemented and used, whereas trade sanctions are coming and going according to the political events of the time. So I think we need to enter into this area with a great deal of respect for the importance of the promotion of arbitration. Now, looking at the issue of arbitrability, it's very closely connected to the companion issue of public policy. Now, UNCITRAL has talked, at the time that the UNCITRAL documents were being made in the context of the 1985 model law and the 2006 amendments, and in various working group discussions, whether or not arbitrability should be tackled from an international perspective. And it has been left to the states because it's so closely connected to their state interests. Arbitrability and public policy represent a vent for states to protect their most important state interests. And there are movements afoot to try to tackle arbitrability from an UNCITRAL perspective. It's been something that's on the radar and on the agenda. We'll see if that does come out in the coming years and work. And bearing that in mind, we should try to take an international approach to arbitrability. We should not take one which is only protecting the interests of the sanctioning or the sanctioned state, but try to rise above that. If we look at the New York Convention, we see that arbitrability will come into two different points. It comes into Article 2 on when a court in a state, which is under the New York Convention, which is just about every state in the world, and there are some more states that are looking at accepting the New York Convention, then that court should determine whether it will give effect to an arbitration agreement. And if the arbitration agreement meets the formal validity requirements, which we know are quite low, then it should give effect to that arbitration agreement. But there is the opportunity to not send the matter to arbitration should the court find that it would violate their notions of arbitrability. But that should be very restrictively applied. The other opportunity for arbitrability comes in at the end of the game instead of at the start of the game, at the time that the award has been made. And then we have the opportunity under the New York Convention under Article 5B for a state to refuse to recognize and enforce an award if they find that it would violate arbitrability. But these concepts, both in Article 2 and in Article 5, should be restrictively applied to almost the most important types of issues. And the companion issue is the issue that was brought by our colleague from Qatar on public policy, the unruly horse. Now, again, public policy should be very restrictively applied. I had the pleasure of sharing a panel a bit over a month ago with Jennifer Kirby, who is a very experienced arbitrator, at an UNCITRAL conference on the New York Convention. And she had the position of discussing, is there transnational public policy? And she made a very convincing case that there is no such thing as transnational public policy, that the New York Convention envisions that each state shall have a very narrow opportunity to avoid enforcing an arbitration award in the very, very few cases. That leads us to the question that we have before us today, which Jaroslav has very well put on the platter for us to dissect, and that is, do trade sanctions rise to the level that the arbitrability and or the public policy exception should be applied? I say no. No, no, no. Not every court will agree with me, but let me give you some analogies of what is argued to be arbitrable. And I can give you some case examples from Stockholm. You can find them from around the world. There are many supposed important state interests which create supposed mandatory law. One area that I think you're all familiar with, which has been dealt with and pretty much decided, is competition law. The EU Court of Justice has said that competition law belongs to important EU policy, and that reviewing courts should consider it when reviewing awards. That was the Benetton Swiss case. It doesn't keep us from arbitrating distribution contracts when one party claims that it violates EU competition law. EU competition claims come up all the time. Troublesome sometimes, yes. But experienced counsel and experienced arbitrators deal with it. And so do courts when they're having to deal with annulments or reviewing. Securities law, that also is considered to be arbitral, even though it involves very important state public interests. And even though it's subject to state authorities who regulate, it doesn't prevent arbitrability. Anti-money laundering law. It's based on the FATF recommendations, something of huge importance internationally, something which many people would say has an international important policy. That doesn't mean that as soon as somebody claims that activities in the transaction might violate anti-money laundering legislation, that we suddenly proclaim that the case has to be dismissed and unarbitrable. Bribery and corruption have been issues which are hotly discussed and often occurring in the context of arbitration. But the general provision has been that the mere claim that something might violate anti-bribery and corruption laws does not mean that the arbitrator should shut down the case. They should deal with it. Using the doctrine of separability, which Jaroslav set out, they should investigate the claims and then determine whether or not those claims are valid. If so, they dismiss the case. If not, they move on to a decision. Currency controls. We recently had a case from the Swedish court in which a golf course in Moscow, the Russian party claimed that the mandatory currency controls in Russia prohibited the arbitrators from taking the case. In Sweden, that is not a matter of mandatory law, the seat of arbitration. And the court confirmed it does not affect the arbitrability of the dispute in Sweden. It may prevent enforcing the award should the Russian party lose in Russia because of the mandatory currency controls. But there could be assets in any other number of the countries of the world, maybe in some Mayfair property. So it can continue. We had another recent case in Sweden, a large case involving an American company and a Russian company, where large amounts of uranium were being resold for energy and other purposes, and the Russian company claimed that the dispute should be dismissed because of illegality. It turned out that the Russian party and the American party were both being investigated for tax fraud, and in a very criticized decision, the arbitrators dismissed the case, finding illegality, and that therefore they would not go forward with the case. That's been much criticized for not proceeding with looking into the merits of the case based upon claims of tax fraud. Tax authorities can deal with the issues of tax fraud, if there was any tax fraud. We have other cases. We all know, for at least those of us who are dealing with the former CIS area, there's lots of issues that have come up with corporate governance disputes. We had Ukraine and we've had Russia. We have some different case law and things happening, declaring corporate governance disputes as non-arbitrable. We have, as a result of some arbitration cases, we have both decrees from courts and then legislation saying any arbitration award involving the liability of directors in the corporate governance disputes will not be enforced and are inimical to public policy interest in these CIS countries. That hasn't stopped arbitration of these disputes. It goes on all the time. It may stop enforcement in a Russian court or a Ukrainian court, but there may be assets otherwise. Or it might be that the claimant wants to get an arbitration award because they have perhaps tax write-offs. If they reduce this to an award, there might be insurance, there might be guarantors. There could be other reasons why a claimant wants to get to an award, even if they can't enforce it at the home jurisdiction of the debtor of the award. Cultural heritage disputes. So we have many things which could be claimed to involve public policies, and that hasn't stopped arbitration, and neither should trade sanctions, even though they might be met with problems on enforcement. And it does, I would venture to say, I suspect that Benjamin might say to me, "Oh, Patricia, you're forgetting. The penalties for getting involved in a trade sanction are much more severe than if it's corporate governance dispute or tax evasion issues." They can be draconian. Still, I would still argue that we need to deal with this as we deal with other areas of important public policies and not make an exception for trade sanctions, particularly because they are so dynamic and changing. They're being amended all the time. And what happens if we do say that trade sanctions are not arbitrable? What happens? If you find that this is a jurisdictional decision, as Yaroslav has suggested, then that means that this dispute is not going to go to arbitration. But under most trade sanctions, indeed under the US-Russian, which are the probably most draconian we can find, a party is entitled to have a determination of whether or not the particular claim or defense falls under the trade sanction, or if it's subject to an exemption or not within the scope or whatever. Who should determine that? If you find it's not arbitrable, where should that determination take place? If the parties' arbitration agreement is broad enough and with the presumption, which is in favor of arbitrability and interpreting the scope of an arbitral agreement, if it's broad enough, the parties have agreed that they want the determination to be made by expert arbitrators. And if you say this is jurisdictional, where are you sending the parties for the determination? Where should they go? To a court? Which court? The court at the defendant's domicile is a likely place to end up. Is that the place where this decision should be made? It's completely contrary to the overriding principle of party autonomy. And it would create a tremendous Swiss cheese out of arbitration. You would go right back to the problem that you had in the Prima Paint case. As soon as somebody says trade sanctions, we shut down the arbitration. Any recalcitrant, obstructing respondent could raise the ugly head of trade sanctions. So I say we should be bold. Arbitrators could look at trade sanctions not as a jurisdictional characterization, but as an admissibility issue. Say we have jurisdiction, but we will take it and then we will explore whether or not this dispute is admissible. We will adjudicate whether or not the trade sanction has an impact, and then later, at the time of annulment proceedings, should they be brought, or at enforcement and recognition, a court can then have a supervisory function, as we've seen in the cases in Switzerland and such, which are cited. And those courts ought to give deference to the fact-finding of the tribunal and to the legal determinations of the tribunal, and they should treat them as they would treat any of these other types of areas that I've brought up on their review of the arbitral award. So I argue we should be bold, we should be robust, we should not ignore trade sanctions. They should be considered, but they should be considered in the context of arbitration. We should not let trade sanctions undermine the system. The consequences are too severe. Now, I'm hoping that in our panel discussion, because I'm quite aware that you don't want to listen to me all afternoon, but there are some juicy questions I haven't addressed that I'm looking forward to addressing, and I think are particularly relevant to you here. And that are the questions which have already been kind of highlighted, and that is the issue about what does this mean for arbitral institutes? What does this mean for arbitrators? What happens for people who are within the jurisdiction of these trade sanctions? And it is an issue. I can say anecdotally, it's been raised in ICC, PCA, SCC, LCIA cases, whether or not the arbitral institutes can accept payment from parties who might be related to targeted companies. And because some of these trade sanctions are so broad that it can capture subsidiaries, it can capture a U.S. national who may be acting as the manager of the non-trade sanctioned company. They can be very broad, and the problem has come up of whether or not the arbitral institutes will be running amidst their trade sanctioning legislation when they're sitting in countries which have issued such sanctions by accepting money. In one anecdotal case, the ICC couldn't take the money in U.S. dollars through their Europe-based bank, but instead had to go to a small bank and make it in a different currency. And there's also been issues about paying arbitrator fees out to arbitrators on panels. There have been issues with ICC in New York because it's based in their accounts with U.S. dollar accounts through their arbitration fees. There are issues that we've been talking about whether or not can Benjamin, as a citizen of Texas, you know, probably the most patriotic state you can find, is it a problem for him to sit as an arbitrator if one of the parties is a targeted or related to a targeted company? And does that also create, apart from issues of whether or not he will be receiving compensation from a targeted company, does it also create issues if he was to make an award which would require one party to pay to a targeted company money? Does it create an issue that he might be challenged because of his relationship to the sanctioning company and countries? So these issues are circulating around. They haven't been dealt with yet, but I again suggest that you're not going to see ICC, LCIA, SCC, the Swiss chambers. You're not going to see arbitration in Europe just shut the door to all these targeted companies. There are efforts being made to work around it. I can say last night, as the vice chair of the board of the SCC these issues we've addressed. We have a lot of east-west arbitration, and I sent an email last night to find out whether or not the policy paper we're working on is ready for public notification. Not yet. It should soon be. We're still working on it. I think at the next board meeting it will be accepted and get posted on the website, what our policies on some of these issues are. I've had discussions with other arbitration institutes, people in the Secretariat and Managing Council and such. These issues are being very much discussed, and there are efforts to try to deal with them. They're troublesome, they're pesky, but I don't think we're going to see arbitration shut down. But we do have, it's been clearly expressed, that many of the companies in these targeted countries are looking east. They're looking for options in the east because that helps to avoid the problems. So there are opportunities there, but I think that it's important that the eastern opportunists need to show that they understand the issues, they're ready to deal with them, and they're ready to deal with them in a robust, rigorous, and legal manner. So I think we should have a good discussion now.